Can you hear me?
Yes, sir, we can hear. We are searching for it.
Coach Rep, class governor, where did we stop last time?
Contract capacity of a company.
I think we discussed, we mentioned something about privilege of contract, I guess. We discussed privilege of contract. Or we didn't discuss that last time.
Last time, sir.
Sorry?
We talk activity of contract. So you just listed it for us, but we did discuss.
So today we continue with illegal. See, on you know, the last time we made mention of the fact that there are instances where a contract, an agreement will have all the elements: offer, acceptance, consideration, intention, and of course, parties will have valid capacity. But then that contract may not be enforceable. But then that contract may not be enforceable. So, um, there's a difference between having a contract. Because when you say that there's a contract, it means that the elements of contract are there. But there's a difference between having a valid contract and enforcing that contract. So, because to have a contract is when all those elements are established in that agreement. But then other factors outside of those elements may make a contract not to be enforceable. And for the purpose of your class, there are many of such factors. You have mistake, you have misrepresentation, you have duress, you have undue influence and things like that. Of course, for the purpose of your class, emphasis on is on illegal and void contracts. You know, a contract is illegal when it is in conflict with established, laws. Once a contract is in conflict with the external laws of the country, then it is illegal. But then, of course, it is also void. When you say that a contract is void, it means that in the eyes of law, it is deemed that that contract did not exist. And so, even though the contract will have all the elements, but if in the eyes of law it is deemed that it doesn't exist, then such contract will not be enforceable. Or where a contract has those elements, but then it's in conflict of the extant laws of the of the land, then of course such contracts will also not be enforceable. Now, of course, there are three justifications why the courts will not enforce an illegal and void contract. One is unwillingness to aid such contracts, because I gave you an example of contracts, involving those criminals that rob a bank, and one of them was disadvantaged and went to court to get um, to get uh, remedy, and was arrested together with a lawyer. So that's just so one, the court will not be willing to aid a contract that is against the law, because the duty of the court is to promote you know law, not to promote those actions that are against the provisions of the law. That's one. And of course, one reason also is that justice will be tainted, and the dignity of the court will be offended. And of course, merely the court is if the court is allowed to accept illegal contracts, then of course the image of the court will be destroyed to that extent. And of course, they need to discourage illegal enterprises, because if you involve in illegal contracts and you go to court to secure protection, it means that many people will be encouraged to go into illegal contracts. So look at some of these um, factors briefly. One is the illegal contract. So can someone read the second paragraph? Can someone read the second paragraph to know that you are involved, you're participating? Can someone read the second paragraph?
Hello, can you hear me, sir?
Hello?
Yes.
Illegal contract. A contract is considered illegal when the subject matter of the agreement violates a law or contrary to public policy. Basically, contracts are illegal if the formation or performance of the agreement will cause the parties to participate in illegal activity.
Thank you so much.
Example,
No, thank you so much.
right. Uh,
So you see that, yeah. So the legal contract, as I said, the subject matter of the contract violates you know, um, the laws or is contrary to public policy. Now, for every contract, there's always a subject matter. Every contract. If um, it is contract of employment, there's always that which the person that is paying you to do a particular something on his behalf in the contract of employment. There's always something that you aim to do. So that the nature of the job that you're going to do as an employee in a contract of employment will determine whether it's illegal contract or not. So for every contract, there's always the subject matter. That is the core, the basis upon which that contract is entered into. You know. So if you enter into a contract because you don't want to spend time to earn your MBA here in the university, and you enter into a contract for someone um, to forge a certificate for you. So you see that that subject matter itself is that certificate which is forgery, and of course see that that itself, of course, will also violate, even though it have element of offer and acceptance and all of those ones. So you can just think about anything that you can, thought of. But once the subject matter of the agreement is in conflict or violates the laws, then of course it is not enforceable. That is, the court will not recognize any right or obligation that will arise out of such contracts. It could be illegal at the time of formation or at the time of performing the contract, because you know that The difference between forming a contract and actually performing that contract. There are two things. So even if the employment is lawful, but then you will deploy illegal means in executing that contract, then of course it violates. So if you have a contract for the construction of a block or estate, you know, but then in order to enable you carry on that contract, you also went to into another illegal agreement whereby someone will, the materials that we use in the construction are stolen ones. Someone can, where someone is stealing those materials from somewhere else and then selling to you at a cheaper rate for you to go on with that construction. See, so all of those ones also be illegal. Anything that's against, you know, so public policy, for instance, are things that society front at, things that are not acceptable in society, whether they are considered, you know, they are covered by law or not. Because so, and of course, there are examples here. Contract to commit a murder. Someone has been hired to go and kill. For sale of drugs that are prohibited. You know, Prostitution or gambling, hiring of underage workers and things like that. Because for Nigeria, the age of employment for contract employment is 18 years and above. And so we are in other ages to be employed, then of course must be such employment that we add value to the life of that underage person. So of course, where a contract is illegal, you know, then it is void. So as we see, void is discussed here as a consequence of illegal contract. That is when it is established that the contract is illegal, then the consequence is that that contract will be void. And as I said, void contract is that which is deemed not to exist in the eyes of the law. So as a general rule, a contract that is illegal, as formed, that's the time of forming that contract is void, subject to subject to you know certain exceptions, as the case may be. Um, and it's based on the fact that maxim, which is ex topic causa non orito action. No action can arise on the base cause, or no action can arise, out of illegal, you know, transaction or agreement, as the case may be. So, of course, there are exceptions which are going to see. Now, you will see those defenses to illegality there. Of course, I told you about a particular case of those armed robbers that went to steal. They agreed that before they went into the robbery, they agreed that look, if the robbery is successful, they're going to share the proceeds of the crime. And one of them, you know, alleged that he wasn't giving what was agreed before the crime took place. So he went and hired a lawyer who went to court to ask the court to pay, ask other co-armed robbers to pay to his client, who was also an armed robber, the agreed percentage before the crime took place. Both of them were arrested. I don't know what do you see about that case? That's the case of Everett and William. Can someone read that case? Can someone read that case on the slide?
Good evening, sir.
Go ahead. Yes, good evening.
Abiodun, sir. So, the case of Everett versus Williams, an armed robber sued his partner to claim his own shares of their loot valued at £200. The court declared the writ as scandalous and impertinent The solicitor was fined for contempt while the parties were executed.
Exactly. So we see that, I told you that before. Imagine such contract, people that armed robbers agree going into a contract, agree on the sharing formula that if they go on the robbery and the contract will, the robbery was also, and because they win, they pack money, pack jewelries and everything. But this very one, complained that he wasn't giving his own share, you know. So like we see just and there are many other cases that you can always read or many of them, and of course illegality. Um, can There are many examples of illegality, but as I said, any contract that is against the law or contrary to public policy, you know, a public policy is that which is not the standard of acceptability, what is acceptable in the society and what is not acceptable in the society, and things like that. So, but then what we're saying that no matter how you go into a contract, an agreement, it must not violate it, because if it violates any of those such laws, then of course that contract will void. As I said, the in law, everybody is presumed to know the law, so there's nothing like ignorance that you are not aware of it. Ignorance is not an excuse at all, because everyone, you know, is presumed to know the law. Now, for a void contract, as I said, a void contract is that which the law disregards or does not recognize as capable of giving rise to any rights or liability for reason of public policy. Now, because I'll give you the example of, you know, uh, a void contract, and then if you go back to formation of contract, what contract does is that it creates rights, it creates obligations, duties, what each party will agree to do. So even in the between your contracts with University of Lagos, for instance, there are those things that University of Lagos have agreed to do, and of course those things that you also supposed to do. So there are rights and obligations. You have to pay school fees, attend lectures, write exam, and do all of those things. University of Lagos is to provide you with the lectures and all of those examination, and then they'll give you a certificate at the end of the day. So you see that those are obligations that if the University of Lagos will fail on any of this one, you can always take action to enforce your rights and obligation that arise out of that contract. Now, but we're saying that when the contract is void, when the contract is against the rules of the land, then it is deemed that those right obligations that what we talk about here did not exist. So you can't claim any right, you can't claim any liability, you can't claim that look, so assuming that you know you forge this, because to be gain admission for MBA, there are certain requirements that you must have, right? So assuming that you lie on oath, you forge those requirements, and University of Lagos did not know that you forged the requirement, and it's now discovered, at the time of, lectures, or time that you became a student, lectures were going on, that it's discovered that, oh, you forged your credentials, that is contract that's illegal at the time of forming it, that you forged your credentials, so once that is discovered, then of course, nothing, you can't claim any right under it at all. You can't always say that University of Lagos is liable to do XYZ to you because of that illegality and the contract, because the contract was void. So when you say it's void, it means that at the beginning, at the time that you're going to that contract, it's deemed that no relationship had existed. You know. So, and I give you examples of it, like manufacturing companies, where you're supposed to, whatever products or drugs that you need to manufacture in the country, you must have NAVDAC number. Where such is missing, then of course it becomes a void contract. You know. as the case may be. Okay, if you look at the case of Savannah Bank versus Gilo, those are you lawyers, some of you that are practicing the land law, it's a popular case in land law, which is to the effect that, you know, you cannot transfer any valid title in land or interest in land without the consent of the governor. And so, you read the case of Savannah Bank versus Gilo, which is a popular case in land law, you get some of those, one of those examples, in the contract of, in the mortgage contract, somebody that are into banks, somebody that work in the bank, you familiar with mortgage agreement, where someone has borrowed money from the bank and uses his own property as collateral. The bank is expected to, reserve that mortgage, and of course, the bank can't take over the property unless the consent of the governor is obtained. So if you do that, if you don't do that, obtain the consent, and then you sell that property to, the bank attempt to sell that property to be another person, that will be in breach of what the law says. You know. So one other example of illegal contract is contract in restraint of trade. So you as professionals or business people, there are instances whereby you enter into agreement with your servants or with your staff, or some of you that have entered into agreement with your employers, to the effect that you will not carry similar, you will not go into similar business or carry on similar profession or trade or deal with some clients, you know, that you are exposed to in the course of working with a particular company. It's a common thing. It's very common that when your employers will stop you from carrying on or having any deal with any of the customers that you are exposed to in the course of your employment. Some will say that you cannot even open a business like the one you're working, with now. You can't open that similar business close to where they are. So many of those things, in that regard. So the question is whether such contracts are void or not, because by law, every person have right to work. You have right to association, right to work with. So you can, to practice your own freedom to practice your own profession. But here we are now. You enter into agreement. The employer and employee have entered into agreement whereby the agreement is saying that the employee will not carry on his own profession or business or trade, you know, in line with, there's a conflict with. So if you have such agreement, for instance, the question is whether such is illegal or not. So even this one also said it's an illegal contract because it violates the right of the employee, that is freedom to associate or work with any person, things like that. Because, as I said, there are also exceptions to that if indeed, you know, that is also desirable. So there are instances whereby you can justify that, you can justify the reason for, contract in relation of trade. So in the past, the contract in relation of trade was prima facie void for public policy. Those area you know, because it it was void in the past because it tend to, promote monopoly. So in the past, we have an agreement. Some of you that are working, go and check your agreement whether you have signed. There's any clause that restrain you from carrying on your profession, your profession or business, or dealing with customers of the place you are working now. Check such agreement because it's very common. Now, as I said, when employers try to stop people from working, also that they're trying to promote what is called monopoly. And so in the past, such agreements were void meaning that they were not enforceable. It then means that in the past, if you have such an agreement, you can still disagree with, I can leave the disregard the agreement and deal with those customers or carry on your professional business, as is required. But then presently, it is justified, you know, in other words, in the modern society now, employers are allowed to stop the employees from carrying on similar businesses or profession, on the following grounds. You could see there one, two, three. But one is where it is reasonably necessary to protect the interests of the person in whose favor it is imposed. When you say that something is reasonably necessary, reasonability is a question of fact and circumstances in this case. So what can be reasonable in one case may not be reasonable in one case. So it's a question of facts and has to be proven. And of course, where it is not, unreasonable regards the person restrained. So if it is able to protect the employer, fine. But even if restrain the employee, but it's not reasonable, it doesn't have anything, it doesn't affect that employee, then of course it will be allowed. And of course, the last one is where it is not injurious to public interest, as the case may be. That also will be so. But the summary of it is that look, it's a question of fact and circumstance in each case. But at least is a departure from the old law, which says that you cannot have an agreement whereby you stop your employees from going in other business that are similar to or in conflict with the one that you are employing that person. That was what the law was at the beginning. But now, such clauses in the agreement are permitted, they're allowed, provided they fall into this category that we pointed out there, which is all about whether that constraint is reasonable in the interest of the employer or in the interest of the employee or the general public. So those are the things that you need to take note of. There are cases there. You can see the case of Leon Torres and the Nigerian Textile Mill Limited. They are all online. You can Google them and get the facts of each of those cases. Right. So, as I say, there are other types of factors that can make a contract not to be enforceable. Mistake, where you enter into a contract under mistake as to facts. There are sometimes that you are dealing with a subject matter that's yours. Assuming that you lost a car, lost your car, for instance, and then you go to buy a similar car, not knowing that the one that you are buying is even the car that you lost, without knowing, you know. And it could be mistake as to attaching different meanings to it. There are examples of you ask for supply of products. So, you want to supply like cars, for instance, which have different model. You have a different model in mind. The person supplying you also have a different model in mind. You see that the two minds are not agreed there, even though. So they could mistake at that level. They could also be what they call misrepresentation, which could be fraudulent, it could be carelessness, true carelessness. But then the facts that are presented did not represent the true state of affairs, and things like that. So there are so many duress is there, economic duress. Someone, you clear a container for somebody, you are supposed to deliver those container, but because that person is owing you seize that container that look, oh, if you don't sign the agreement this agreement, I will not release the container. Those are economic duress, you know. Undue influence, many of such factors, they also make a contract not to be enforceable. So there are many of them. We just take note of the fact that illegality, for as businessmen and women, pay attention that the contract you are going into is not illegal. And the beauty of it is that, look, oh, you cannot claim to be ignorant of law. So everybody is presumed to know the law. So if we enter into an agreement that's contrary to the law or against public policy, then such contracts would not be enforced. Despite the fact that it will have all the element, would have had all the element of contract, that is offer acceptance and the rest of it. So, ladies and gentlemen, these are things that you need to know with respect of illegal and void contracts. Do you have any question before I proceed?
Yes, sir. Good evening, sir. Please, I have a question.
Go ahead, Nose.
All right. Thank you very much, sir. I'm not totally clear on these justifications for restriction of trade. Because, sometimes when we look at these things and we throw in these legal terms, of course, it can be quite confusing. So if you can just help me with a practical example, because when you say that you can restrict trade if it's not unreasonable to the person restrained. So for instance, if I'm working for a company and I'm rendering similar services to another company, the company I'm working for can restrict me from carrying out those services if I don't find it unreasonable. Am I getting that right? Because I'm not really clear as to where the restriction, what are
Okay.
the battery limits of these
So,
restrictions?
so what? This is what happened. In the agreement, what happened is that when you are working with someone, either in a trade or profession, maybe accountancy or lawyers, even lawyers, those things happen. In fact, I personally had experience whereby you sign agreement to work with a law firm, and the law firm would one of the clauses in that agreement will tell you that look, that all the clients that you come in contact with in the course of working with that law firm, that even if you resign from that law firm, that for 5 years, you will not have any dealing with such client. So this is what the law firm will present before you. So what I mean is that as a lawyer, once you become a lawyer or as an accountant, you are supposed to consult with your client as a So if you are working with a company and then one saying, look, why you are working with me, you cannot work with or consult with any company that has having similar, carrying on similar business with the one you are working with. But you know that even there are sometimes that even at the close of work, while you are at home, someone can approach you, please, help me work this, give me this. So as a consultant, as a professional, as a professional accountant, you are supposed to do. But then here you are, a company that you're working with saying that you cannot do that. As long as you remain employed under them, you cannot work with any company or provide any service to any company that is into similar line of business. Or saying that look, even if you resign, that you cannot deal with that client, that you cannot even there are some that will say that you cannot even establish similar business within a particular area jurisdiction, that you must leave. Some women, there are some that say you cannot even participate, like in Lagos State, you cannot do that similar business in Lagos State, or some will say that you cannot do that such business in Lagos Island, or some will say that. So there are many of those restrictions. Contract in restraining you from carrying on a business, carrying on your own profession, carrying on your own, trade, as the case may be. Whereas you have a right to carry on all those businesses. But because you're working with somebody, that person now say, you know what, because you want to work with me, you must not do this X, Y, Z. So that is the extent that we're saying that. That we're saying that, look, before now, such contract was void. It means that if someone enters before now, if someone enters in the contract with you, that contract will not be enforceable. It means that you can choose to consult with another person while you are still working with that company. You may choose to, even though it's saying you cannot establish your accounting office close to where the office that you're working with is, you can resign and the following day open your accounting firm just next door, next number, just by it. Because in the past they consider that as being what? As being void. But then presently, under the modern society, that has been relaxed. What I mean is that in some cases, the courts will allow that restriction to stand in the interest of the employer. In some cases, the the law will allow that restriction to stand because it doesn't affect you. You that not affect is that is the employee. It doesn't affect you. And if someone says, "Look, oh, don't practice this around this," yeah, yeah, fine. But if they say don't practice your accounting, for instance, maybe in Lagos mainland, for instance, or in Yaba, for instance, you know, the court will look into account. If you are not to practice your accounting firm in Yaba for next 5 years, that it can only be outside Yaba, then is that reasonable? So that question of whether it is reasonable or not is that answer will depend on facts and circumstances of each case. So if the such that look, oh, if they allow you to practice within that jurisdiction, that area, by doing that, it will lead to you taking over the client or the business completely of that person from the employer to you, then it becomes unreasonable. So to protect that person from losing his own business because of you, they will maintain that restriction. Now it could be that while in that business, there are other services that they will not call to where you are working. So you can operate them side by side. It doesn't work. It may just be complementary, to the one that. So the question of whether it's reasonable or what is reasonable, what is not reasonable, is a question of facts and circumstances in each case. But in most instances, the court is looking at it this way. You know, if they stop you from carrying on your business within that particular area, or if you choose to go and operate that business maybe in Surulere, for instance, for instance, instead of Lagos mainland, and you are in Surulere. So if I'm Surulere, whatever you would have gotten if you're in mainland, you still have it there. So you see that you are not, it's not unreasonable. It doesn't affect you anything. So you can operate it from that side. But at least they're saying, so nothing is just not affecting, So as I said, it's a question of facts and circumstance in each case. And you must provide a look, well, if this is for interest of the employer, because if they allow you to carry on the same profession, the man will lose, the company will lose business, will lose, because there are sometimes that also depends on level of involvement in that company. If we're involved in management, we're working in a such place that you have all the trade secrets of that company, then you open and operate next door. It means that you want to run that company down. So even sometimes your own position in the organization will determine whether the restriction is reasonable or not. So if you're in management, it means that you have management secrets. But if you're not in management, it means that you might not have management secrets. So even if you want to carry on that business, you might not even know how it is done because you are not involved in management. So there are so many factors that are put in place in that regard. I think that's just what I want to put. And then of course there are cases. You can read those cases and you can find out uh, how this is done. Can even Google this case, Leon Riches and Nigerian Textile Mill Limited. You can also try that, read it out. It provides facts where these principles were applied. Yes. Any other question? Yes, any other question?
Yes, sir. Please, I have a follow-up question. Sorry
Go ahead.
for dragging us. Because I have a practical case. So where I currently work, some years ago, someone resigned and set up a business that was performing services similar to one of the services we perform. And just like you said, he was in management, and so he took some of our clientele. It didn't really affect our own business, but he just took some of the market share. Now, after that happened, the management now gives everyone a letter to sign saying that once you leave the company, you can't do business with any of our clients. As at the time you leave, anybody on our clientele, you can't do business with them for another 5 years.
Yeah.
Now, the issue with that is the industry we work in, the oil and gas industry, it's quite small. The clients are not so many because people that operate our assets are not very, very many. And now the way this thing is written is you can't have any business dealings or consult or have any dealings with them. If tomorrow I want to leave and I want to join Shell, for instance, Shell is on our client base. So by me transferring my employment or by Shell recruiting me, I would already be engaging in some kind of business dealings with them because I'm rendering them a service of my expertise or my experience, which they will pay me a salary. So how enforceable is this? Does this mean that my current employer can? I mean, I doubt it will ever get to that extent, but practically, does it mean that my current employer can restrict that movement because I've signed a document
Yeah.
considerably under some kind of duress? Because at the time, nobody wanted to lose their jobs. So they say, if you don't sign this thing, then it means
Yeah.
you have plans, so you can go. So I'm
Yeah.
just wondering, how enforceable is this moving forward? Because there's a 5-year period. So you can't, if you either want to set up a business or whatever you want to do, you can't work with any of our present clients. And our present clients are basically everybody in the industry because we are quite out there. So how enforceable is this? To me, it's not reasonable, but that may just be to me. Like you said, it's based on, I think, facts at the time. So if you can help me clarify this practical example, I think it would really,
Exactly.
really
So
make everything clear.
exactly. So there are many reasons. There are many reasons why a company they will do that. Some they will say that look, oh, because you are an employee, there are some you are in management, there are some trade secrets, there are some secret that you have. That once you leave them and start practicing, you use those secret oaths. There are some confidential information that you have, and because they don't want the employees to misuse such information, they don't want to do all those. And sometimes it could even be the customers that there are sometimes that the customers that that were dealing with you directly. Now, when you move and establish a business in the next place, what they see is that that you are working in some companies. That what some customers see is that they attach a face to you staff than the company itself, such that when you leave, when you decide to leave that company, they leave some client they live with you because they are attached. They won't believe that you are working for somebody. They don't feel that it's you that will make things happen. So, and because of that, that will be just the reason why the company will insist that that should be done. Now, so the question of reasonableness is, as I said, in law, when you whoever allege must prove. That is, if a company is saying that look, oh, it's unreasonable for that person for you to do that, the company should be able to prove how it will be affected if they allow you to operate that business. So it's not your burden now, it's the company. So that if the company cannot prove it, then you're allowed to do your own business. That's how it is. So if it's you now that is trying to prove that you're practicing similar business does not affect the company, then it's your duty to prove that how does it not affect. So whatever that you are saying, okay, these are different and things like that. Okay, now you are saying that you signed that because you want to keep your job, but it will stop at that level. Are there some information that you don't gather about these businesses in the oil and gas? Because you're saying that, oh, I agree with you that the clients are not many. So that possibility of you living with another client. Now, fine. But what was your position? Were you in the position that look, you have certain information that if you go out, you go with them. And then, so you see that window of 2 years or 1 year that you are not dealing with a company, it will make a client to have an informed decision that look, oh, yes, this was the fact that you are not there. They are still having what they want now, but they can sit down and decide thereafter to work with you, no problem. And that's why what some people do is that I know of many high profile people, staff, that what they do is that when they resign from the company, they will take time off. They will take time off, like a year or so, stay off or two. They'll take time off. They will not come back subsequently and do similar something. So in that regard, you're not violating on those rules. And of course, even the other company too, they're not treating like that. But when you move from one and then you establish another one similar to it, means it's very suspicious. So it's just because of protecting the goodwill of the company, protecting the trade secrets, protecting confidential information, protecting the client of this. It takes time to have clients. Companies or businesses, you sustain based on the client. So if you employ someone and it moves away with your client, how will you now encourage another person to employ and to be employing people? Because I know that if I employ you, move away with my client. Even you say you're suspicious that if we employ another person, that person too move away with your client. So to protect that and have those confidence, the law will look at this that way. So these are just some of the reasons that I need to provide to that effect. But if we allege it, whoever allege such is the one that will prove that this is, uh, you know. So if allege, you're the one that will prove it. Yeah. So, but it's always about competition. That's the bottom line is competition. Competition. They don't want competition. That's the truth. You know. But unlike before that, such contracts were not enforceable, were void. Such terms are not void any longer. They are not void any longer. There. But just that, if you want it to be, if you want that protection, you must prove why it should be so. So if it's a company that wants that protection, the company must prove why it is so. you know. And if it's the employee that wants to be exempted from it is the one that will say, "Oh, these are the reasons why it should be exempted." And once you are able to prove, you know, substantiate your argument, then you're allowed to carry on with your own business. Hello, hello.
Yes,
Hi,
sir.
hi,
Yes,
sir.
Yeah.
Yes,
So
sir.
thank you. Thank you very
Yes.
much, sir.
you can provide your own justification why you should be allowed to practice similar business. If you can able to convince the court, fine, they'll allow you. Unlike now, before now it wasn't like that. Before now, such agreement were void. None is not void at all. But it's the person that wants to benefit from it, or don't want to. If the company don't want you to benefit from, I mean, they don't want to go out of it, they have to prove. If you are saying, come and say, look, oh, we need that clause to protect our own interest. Prove to the how is your interest protected if we allow that agreement to stay? So if it's you that is affected as employee, you have to also prove that, oh, this is unreasonable, it doesn't protect you. Prove how it is so. That is just the basis open. And of course, if it is for injurious to public interest, all of those ones must be proven as the case may be. So if you look at even the Nigerian textile limited, for instance, why they were talking about the fact that this person was manager, the textile company was in Lagos, but the fact that, and the prohibition of 2 years, in the was the fact that, look, oh, the textile industry was then, so was going on very well. It was traveling throughout the whole Nigeria. It wasn't just in Lagos alone. It was throughout the federation. That was why they insist on all of this. Any question?
Yes, sir. I have a question.
Yes. Go ahead. Go ahead. Go ahead.
My question is quickly from where my learn for this person.
The line is cracking.
Can you hear me now, sir?
I think it's better.
I think my question is, I want to take it from where my learn for this story. Now, my question is like this, sir. The subsection 6 of the Nigeria Constitution says that I'm entitled to freedom of association, that I can associate with anywhere I want to be. So my question not border on my company can restrict me from doing certain things because they don't want me to work or maybe excuse their system or to visit their client. How will I now enforce that my freedom of association?
Contract. That's why it's contract now. Contract is voluntary. You bargain for. There's the they are is this what we're talking about here. There are what they call fundamental rights that cannot be taken away. But then there are also some that you can also be. There are some of those rights that you have, freedom that you have that can be, can be withdrawn in the interest of in the public interest or in the interest of the society or all of those ones, and of course, or it is the law so permit and case like that. So remember that agreement is itself a law. When parties enter into agreement, it's as good as enacting a private. That is a private law on its own, and that's why they can, just the way a law will have section 1, section 2, section 3. Your agreement that have section, paragraph this of your own agreement is also as binding as you can have a law having section this, section that. And that's why it's expected that, look, at the time of negotiating the agreement, if you don't want it, well, you shouldn't have gone into, you accepted that in the first instance. So why do you even accept in the first instance, not now coming back and saying this? So you see that it's not in agreement, what the law is saying, look, in agreement that is, that has a clause or that's in restraint of trade, does not violate, any of your rights. It doesn't. Unlike before, because it's agreement, you have the right to say, look, you know what, I won't go in this way, but you accept it. So is in trying to balancing. They are balancing things here, balancing both the interest of the employer and the interest of the employee. Unlike before, the concern was only for the interest of was meant to protect the interest of the employees only. That's why the law said, look, such agreement were void because of monopoly. They were encouraging monopoly, right? So, but in the modern law now, they disregard the issue of monopoly now. Hello. So in the modern side now, it just create a balance between the two of them. So it doesn't violate your only right that you're talking about there at all. But you have the right to say, you know what, you're not going to that. Like those example of the other colleague that said at that time, if they bring out those forms for you to sign, you have at that moment you have the right to say no, you're not signing, you resign and go, but you accept it. So it becomes part of the rules that will be used together to regulate your dealing with the company. So you cannot choose to benefit from one and then deny another person from benefiting from it, as the case may be. That is just my own response on that. You can read those cases, as I said, read those cases, and then you can get more of such, examples, as the case may be. Yes. Okay, so let's go to the last part of the stuff, which is discharge of contracts. Now, having looked at those factors that may make a valid contract unenforceable, the Anything that has a beginning must have an end. So we look at the element of valid contracts, look at terms of contracts, look at examples of contract that instances whereby a contract will not be enforced, even though it has all the element of it there. Now the other one that we need to look at it briefly is discharge. How does the contract come to an end, and what are the remedies? So in law, a contract comes to an end. Yeah, someone should read the first paragraph. Someone should read the first paragraph.
A contract
A contract
is a
is
discharge
discharged
when the contract is brought to an end and the parties are freed from their mutual obligation. A contract may be discharged in 4 ways: by performance, by agreement, by frustration, and by breach.
Okay, thank you. So when you say that a contract discharge, you mean that that contract has come to an end, it has been terminated. And remember that there are 4 ways of terminating it there, or bringing a contract to an end. Those things that will happen when a contract comes to an end, and of course, remember that I mentioned that before. Let me also mention it here again. There's a difference between termination of contract and termination of an offer. So that makes these two up. What are the various ways of terminating an offer? How does an offer come to an end? What are those means of bringing an offer to an end? By what and by what and by what? I still remember. Yes, you have forgotten completely what I talked about in regards to termination of an offer. You have forgotten completely. Do I have people in this class?
Yes, sir. We are in the class, sir.
We are with you, sir.
What are the ways of terminating an offer?
So we have
What's-
by revocation, rejection, by death, and lapse of time.
Thank you. So when it comes to that offer is at the time that the contract was about to be formed. I know that I said that once the offer is terminated, nothing to accept again. And without acceptance, a contract cannot begin. And so if we're talking about discharge of contract, we're saying that the contract has survived all the elements, the contract has survived the areas, those are illegality and all of those ones. Is valid, and subsisting. But how does it come to an end? 4 ways: by performance. So once a contract is entered into for a particular purpose, and so once that purpose is achieved, then that bring that contract to an end. So as I said, once it's performed, so if it's contract for supply of X number of goods, that will supply. If the contract for consultancy and you provide the consultant services, as agreed, it has come to an end. Services, if contract of employment, for instance, even employment, even in the public sector, you know, if they hire you to carry out a particular transaction and you've done that, that comes to an end. In the public sector, retirement age is also there. And so, if it's construction, after construction, if it's for supply, after supplying those services, if you purchase of goods in the superstore, once you pick those items and you pay for them, that's ended. So performance is one way. And of course, the general rule is that as general rule, the performance must be total and exact before it can be discharged. So for instance now, a contract for supply of uh, 1 million or 1,000 bags of maize, it must be 1,000 as agreed. If it's for construction of blocks of estates, it has to be like that. If it's a contract for lease of a warehouse, it has to be exactly as agreed. If a contract, for renting of an office space, it has to be. So it has to be exact based on the terms of that contract. We have looked at terms of contract before. And of course, we know that, terms of contract evolves from offer, terms of an offer, which if accepted, begins the contract. So there are exceptions to the rule that performance must be total. Is what they call, substantial performance. You know, just the way we have, you know, it's a popular language in elections. Elections, even though every person above 16 years and above supposed to vote, come out and vote for leaders. If you don't come out, but there's substantial compliance with the electoral act, So you see that there are many instances whereby elections are conducted. Just this is not business anyway, but just give me an example of it. He said elections in Nigeria are to be conducted in line with the electoral act. But in most cases, you hear the electoral commissioner saying that it's not there's no total compliance, but there's substantial compliance. So it could be contract for supply of 1,000 bags. 900 were supplied, 100 are still missing or pending, or 50 are still pending. You see that there's substantial, performance. So at that moment, the other party will now decide to accept it as being the whole or not. Then you have, situation whereby a contract will divided into several, when you have several contracts in one, like in construction, for instance, construction, you have what they call milestone. When you lay the foundation, they will pay you for that. When you lay the blocks for the first floor, they will pay you. So based on the milestone that are agreed. So you see that when it comes to all these abandoned projects, what they call abandoned projects, it means that the client had failed to give money for the next phase of it, and you see the project being abandoned. You know, so when you have several contracts in between, uh, uh, you know, some are perform, others are not. You can still deal with the one that have been done, and then you pay in that. So if, for instance, you're working for your salary is for 1 month, you're supposed to work for 1 month and get your salary 1 month salary. So if you work for 3 weeks, if they cannot deny you the salary because it's not total, because the total must be 4 weeks for you to earn the salary. But even if you work for 3 weeks, not 4 weeks, it's still substantial. Even though in some companies or some organizations they will still pay you less than that week that you could not go to work. Prevention of performance, where the other party is the one that prevented you from performing your own obligations. They cannot insist that the contract must be total and exact. So performance, as I said, is one way by which a contract comes to an end once performed. Carrying on the obligation that you agree in that contract. That is the whole essence of performance. You carry out the obligations as contained in the contract. If your obligation is to go to work, you go to work. If your obligation is to pay salary, you pay salary. If your obligation is to supply those services, you supply those services. So but once you carry on what you agreed to do in that contract, the life of that contract will come to an end. One way, another way is by agreement. You know, so here we are saying that look, just the way parties can agree to come together in the contract, they can also agree to part ways. You know, the pathways they agreed. Yes, they agreed to come together as in the contract. They also agree. You know what? Let's just sever this relationship. Let's just stop this transaction. So you sit together and you agree on how you want that to be discharged, as case may be. Then you have discharge by breach. Is by breach occur when you fail to perform your obligation, either totally refusing to perform it or partially, you know, or you perform in your performance is not in compliance with the terms of the agreement. That you amount to breach of contract. So once you say once you hear that there's a breach, it means that the party has failed to carry out its obligation or her obligation in line with the terms of the contract, or below the terms of the contract, or partially not in compliance with the terms of the contract. You know, so that's a breach of contract. So the one way that breach has to be actual, but then there are sometimes that you know you anticipate someone breaching your contract. That is, the person has not actually breached the contract, but something has played out which suggests that this person, you have anticipation that this person will breach your contract. And of course, it is called anticipatory breach. That is before the date that you're supposed to perform the contract, something has happened to suggest that you will not be available to perform, or you will not be able to perform that contract at that future date. It is called anticipatory breach. So, which is different from the actual breach. Actual breach is when what you are supposed to do, you didn't do it, or you didn't do it in line with the terms of the contract. But this one, before the time for performance itself, something event has happened, which suggests that that future date that you're supposed to perform, you will not be able to perform it. Right. So, can someone read second paragraph of the slide, so that we can know we're all together? Yes. Second paragraph.
Second paragraph. Anticipatory breach occurs when there is a contract between two parties to be performed at a future date, and one party has shown either by words or action that he has no intention of performing his own side when the time arrives. A party could sue for breach of contract, notwithstanding that the time agreed upon for performing has not yet arrived.
So there are many instances you make contracts for. You are asked to perform. You ask a contract to perform at the birthday party tomorrow, and they saw you at the airport today, flying to US or UK for holiday. Even though the performance of that contract is tomorrow, the fact that you are traveling to UK today makes it suggest that it will not be possible for you to come back again tomorrow and perform the same contract tomorrow in the morning. So there are many of such examples there, that when you enter into a contract with someone and performance is to be at the future date, right? There's a warehouse you lease, or maybe an office building, enter into a contract, and the person say, you know what, contract for lease of that building, money was collected from you. You are to take over the property next week. But then you saw that someone was parking in, somebody's now, before next week will come, you saw someone parking into that property, into the same property. It then shows that by next week that you're supposed to take over the property, it's not possible because someone is already occupying that place this week. It means that when next week comes, that place will not be available. So you see that even though taking over is in future, based on what has played out, it clearly shows that that property will not be available to you. And so that is to now be called anticipatory breach. Because one party has shown either by the decision that, look, the intention will not be intended to perform his own side of the contract when that time arrives. So you can sue. You can sue for that. You don't need to wait till that next week before you sue. You can sue that, look, you can sue for anticipatory breach, because by next week, which was supposed to take the property, someone was already parking somebody that have experience of landlord that will sell one house to million people, or give rent rent one apartment to. So what they do is that when they rent to more than one, any person that occupies the place first, always takes charge. Why other people are pursuing their money, as the case may be. But then if there are circumstances that could show that, look, could justify why the person will giving that rent to someone else and not you, fine, it may be excused on that regard. So just know the difference between, or if I may ask, I hope you know now you can understand the difference between discharge by breach and anticipatory breach. I guess you understood it.
Yes, sir, we understand it. I understand it. Well, I have a question, sir.
Yes, go ahead.
Okay. So as regard this anticipatory breach, the examples that you have made, but then I just thought of another example. Say somebody that is supposed to, let's say a lawyer that is supposed to represent someone in the court the next day, and then today the lawyer falls ill, and to the extent that he was taken to the ICU. So which means that he's not going to be able to represent the person the next day,
Mm.
obviously. So in that case, I know the person already knows that it's not going to happen. So can the person sue? Because looking at the situation of things, it's not that the lawyer actually did that on purpose. The person fell ill. These are things that happens. So I just wanted to know what,
Yeah, so
yeah, to have in that case, sir.
exactly. So that's why I said that if you look at the third paragraph, that's what the third paragraph is saying. That if there's any supervening circumstance or event to justify non-performance, then you'll be excused. So the example that you give me, for instance, that person is sick. When you were sick, you can nothing. It's not by you making that you want to be sick. So in that case, the guilty party will be excused lawfully. You can't seek remedy from someone that I'm supposed to appear represent you tomorrow in court, but they admitted me today. It's not my own making, but you see that is a lawful excuse. So you cannot sue me for breach or anticipatory breach because of that lawful excuse that I have. So that is just an exception to it, where the guilty party depends that have done carry out the action either by words or action that shows that you will not be able to perform. If what led to that action or words can be justified in law, then you cannot sue that person for anticipatory breach.
Thank you, sir.
Okay,
I have a question, sir.
go ahead.
Thank you, sir. My question is on this discharge by breach, sir.
Go ahead.
If, for example, I'm into a contract with someone and I have obligation to fulfill, the person also has his own obligation to fulfill. After
Obligation to do
fulfilling
what? To do what?
like both of us have obligation to fulfill. Like I will do, let's say I do first part, the person will complete the other part, something like that. If that is the
Yes.
case. Okay.
Yes.
So I have fulfilled my part, and my part that I have fulfilled will benefit both of us. Okay. Now for him to fulfill his part, we keep on looking for ways to dodge or just coming up with unnecessary excuses in order for me to now say, okay, let's finally end this contract. But by doing that, the part I have done will be of a favor to both of us. Is there a way for me to also make sure, like in the law court, like, okay, even though we are going to breach, like end this contract today, you must do your part so that you don't see I do my own and I'm not the one who has to say.
Yeah. I mean, that would be remedies now. That's remedy. We're going to look at that because you should that the fact that you enter into a contract does not mean that you cannot part ways. The contract will discharge, but then where it is not because there are sometimes that the contract they say will provide on some things that will happen, that if those things happen, the contract will come to an end. you know. So it depends on the nature of the contract. So if you are provided in the agreement, look, if your other party not do, you have done your part and the other party not do his own part within a particular time, then the contract will come to an end, and that other person now who has benefited, we compensate you. That's fine. So that's why we have remedies one of the remedies there is damages. Damages is, could be general damages, could be specific damages, as the case may be, where you are asking the court to compensate you, for carrying on your obligation and the other party failing to carry his own obligation. So that comes under remedies. But you can't insist, except for situation where in contract employment, where the reinstatement is a ground, where the termination of a contract or by employer is unlawful, and the law say and the court reinstates you back to that employment. Other than that, outside of those ones, the law will not insist that you must stay together. But what the court will try to look at, what can be compensated, what kind of remedies are available to you for failure to. So because once there's failure to perform your own part, that's a breach. That is just the truth. Once you fail to perform your own part, that is a breach. Now, as to what will be compensated, what will be given to you, that comes under remedies, which we'll look at it shortly. Right? So the fourth aspect of discharge is frustration. Yes, this frustration here is different from the way you are. Someone common saying that people will just say that, oh, I'm frustrated. You go into a contract with someone, things are not moving the way you want. You just say, I'm frustrated. I'm just exhausted and things like that. That's not the context in which we are discussing frustration here. So, can someone read the last paragraph?
Discharge by frustration. Parties to a contract are discharged, from further performance of their obligation if some unexpected event occur during the currency of the contract without the fault of either party, which make further performance impossible to deliver.
Impossible what? Or what?
For illegal.
So frustration, as so here you are now. When you enter into a contract, once a contract is created, the next thing is to perform that contract. So now, but why the contract is valid and subsisting, but before the parties will perform that contract, an event occur. It was neither the fault of the parties, meaning that the parties were not responsible for the event that occurred. Yet, because of that event, it becomes impossible or unlawful to carry on the obligation. That is frustration in the context of contracts. Parties have entered into a contract for supply of goods. The goods were supplied on Tuesday. You were supposed to make payment on Tuesday. On Tuesday, the government declared public holiday. You cannot go to bank. It was not the fault of the parties that look the public holiday. Contract for supply of particular products. NAFDAC has banned those products in the market. Not your own fault, but you cannot. Contract for supply of goods services in a particular, you woke up and there was public protest. No one goes out for a whole week. That's not your own fault of the parties. Yet you cannot go on with the contract. Contract for lease of a house. Before you move into the house and you move into the house, take over the house, the government have marked that building for demolition. It's not the fault of the parties, but you can't access that property, even though you have paid the rent. So there are many of such examples of, it could be a law that will be enacted that will make that business illegal. It's not the fault of the parties. It could be force majeure, act of God. It could be fire that will destroy the factory. It could be flood that will destroy the factory. It could be electricity that will just so something an event has happened that is not the fault of parties, yet you cannot perform that contract. That is where the issue of frustration comes in. Parties have, enter into a contract to perform their obligations. But then an unexpected event occur, which was not the fault of the other parties. But then because of that unexpected event, then of course it becomes impossible to carry on that contract. So you will see that in most cases, what contract will do is that they will shift obligations. They will, you have the right to contract that if X Y Z happen, then someone should be responsible. So in most cases, if one of the parties have carried out his own obligations and remaining the other one to carry out before the event, unexpected event happen, the one that has carried his own obligation is required to get back, to be paid back the cost of what it is possible for cost of what he has incurred before the unexpected event, took place. So illegal can be, either by way of destruction of subject matter, you know, or where the whole base of the contract is upon the occurrence of events which did not occur. Maybe assuming that the contract was based on election that was to be conducted in Lagos last Saturday, and assuming that that election was not conducted, you know. So, but then what would be the consequences? At common law, remember that when you say common law and equity, just know. I hope you know the differences. Common law is very strict. Equity is about fairness, being flexible. So at common law, frustration brings a contract to an end automatically. You know. So and the contract, does not make the contract, bad, void ab initio. So if money which has become due or payable at the time of frustration is not paid, then of course, as I said, they're enforceable. So if the other party had incurred liability before the event, that is construed as frustration, of course, you can always bring an action to, reclaim what you have done. But any future benefits seized, you can't pay, you cannot, ask for such benefit. There are cases here, fibrosa cases, Chandler versus Webster. You can Google any of such cases. There are many of them. So as I said, it could be enactment of law. It could be, protest. It could be war. It could be, act of God. But the most important thing is that none of the parties were responsible for that unexpected event that have made it impossible for the parties to carry out, to perform their obligations. But if for obligations that were performed before the unexpected event, those ones, are enforceable. But the future ones, sees you can't enforce on them, as the case may be. So those are the things that I expect you to take note of with respect to discharge of contracts. Do you have any question? Any question?
Yes, sir. I have a question, sir.
Go ahead.
So thank you, sir. In this discharge by frustration. So in a situation where a landlord and a tenant are into go into a contract, and maybe the landlord doesn't have a C of O for the building, and at the end of the day, the government demolish the building. Can the tenant sue that landlord for breach of contract?
Is it breach of frustration? You are saying frustration, you are saying breach of contract. So which one are you asking for? Is it so? But that's not frustration anyway. As you say breach of contract. So I guess you know that that's not frustration.
Okay.
Because you say that it's not the fault of either party. So if someone not have approvers, who is it? Is someone at fault or not? I'm asking you the question: is someone at fault or not?
It's at fault.
So you see that once we're able to establish that somebody is at fault, and is the fault of one of the parties that led to that unexpected event, then it cannot be frustration.
Okay.
So that is
Okay.
just
All right. Thank
So I
you.
have a question, sir.
go ahead.
Yeah, so as regarding discharge by frustration. So I'm just looking at the case where a freight forwarder, that's somebody that does clearing and forwarding. So somebody, a client gives the person a contract. I mean, there's a contract for the person to clear maybe a container of goods, and just as the ship is waiting, for the person to begin, there is inflation, which automatically, and the price has been agreed upon. Say, for example, it's 5 million that has been agreed upon, that this is what you're going to use, to clear this goods and all. And so the inflation happens, there's increase in the dollar rate increases, and then also custom duties also increase. Now, this other person, the freight forwarder, is telling the client that based on what has happened, I will not be able to, clear your goods for this amount again. It's going to take longer time. You need to put in money. And the person is saying that, no, this is the amount that you told me. This is what we agreed on. We even have it on paper. And so, from the look of things and the explanation that you have given to us right now, I think this can actually go as frustration. So, I'm asking that, in this situation, if the client decides to actually sue the freight forwarder, would it be seen as a case? I want to know if the court will actually rule in favor of the freight forwarder, as I mean, it's looking at it's already a case of frustration from inflation and
Yeah. So that's not. Thank you so much for the question. So that will make me also to explain something further. So you see that you know where the contract has become burdensome, where in performing that contract, you know the burden is it becomes so more burdensome on one party to perform that contract than as expected. That's not frustration. That cannot be frustration. That is in the course of performing that contract, it became so difficult to perform because of one event that so that itself cannot be frustration. What I mean is that the person can still perform that contract. What I was saying is that the person can still nothing stop that person from performing the contract. Just what you're saying is inflation. It means that if you have additional money, you can still perform the contract. It's not so. Just as you are looking at the profit margin. That if I perform this contract, what will be my profit? Because already you have you know. So that cannot be a frustration because it doesn't make it impossible. Remember that what the issue is impossibility. The fact that there's inflation does not make it impossible for you to perform that contract. So it's not frustration. So what you can have, in such scenario is that is why you can ask for what they call um, um, there are some contracts that parties are allowed to review if such events take place. So you will see that in most modern contracts and parties themselves will make provision for reviewing the rate of the contract if XYZ happen in every modern contract. So I like the question that you asked because where it becomes so burdensome on the part of one party to perform that contract and it's complaining, oh, if I perform this contract, I won't have money again. Not this and that, and you're on your own. That itself cannot be a contract. So it means that you would have put all of this in account when you are negotiating because you see how to perform that. Just like it's become the burden is becoming much on you to perform it. That itself is not a frustration because it is not impossible to perform that contract. It's possible to perform that contract. Just by saying that inflation, this and that. You see, so it's a different thing entirely. If that item that you are supposed to clear for that your client, the law prohibits there was a law that was enacted that prohibit dealing with such item in Nigeria. So if you clear it, where are you going to keep it? You can't clear it because there's prohibition. It's not the fault of either party, but you can't clear it. Or if that's they just ban such so that's just the whole truth. That's not a case of frustration. So I'm glad I asked the question so that you should be able to distinguish between frustration and a situation whereby a party is finding it difficult to perform a contract. So the key word there is impossibility, right? So this scenario narrated is possible to perform a contract. The other is the burden with much. And in such cases, the law is to the effect that that scenario cannot come under discharge by frustration. You still have to perform it. But then, in most cases, where you do not have the what do you call it? If the agreement did not have such terms, the best thing is to go back to drawing board and ask for a review of the contract. That is just what you have to just have to do. And while it is reasonable, of course, the other party also can uh, can listen
Thank
to.
you, sir. Thank you very much, sir.
Yeah, you're welcome. Yeah. So remedies. So the issue is what are the available, remedies available to. So you see that there are four ways of deciding the contracts. Where it is by performance, where each party carries his own duty, nothing will happen. If it's by agreement, they always agree and say, okay, you know what, let's terminate this. So if they have once the agreement, they will always agree on terms of that discharge. So you won't have issue of uh, things difficult to do with and things like that. But then where there's a breach, that's where the problem comes from. Where the party fails to carry its own obligation, where there's a breach of contract, this is where the issue comes from. Yeah. So remedies are in two categories. One is the common law remedies and equitable remedy. So at common law, what the only remedy available is damages, compensation. It can be general compensation, it can be specific compensation. Specific is the one that you can prove, So if it was agreed that look, if I supply you goods, you're supposed to pay me XYZ and you didn't pay me, I can specifically ask for the amount that you're supposed to pay me. That's specific damages. And now, if I incur other expenses to get that money from you, I can put them under general expenses, like getting a lawyer, transportation, writing you, sending you data, buying data to do, all those things. You can just put them as being general, but of course specific one. So you have damages, and then you have equitable remedies as such as specific performance, whereby you insist that look, if they pay you damages, it won't work. So assuming, for instance, now maybe contract for supply of imported goods 4 years or 5 years ago. If they give you that money now, you can't get those goods imported because the rates have changed. The rate has changed. Things like that. So um, you can't ask for specific performance. You can ask for injunction. Like anticipated breach. If you see that someone is trying to, it might not be available, trying to breach that contract when that time comes, you can get injunction stopping that person from going on with any action that will jeopardize, the performance of that contract in future. As the case may be. You can also request for, asking for money hard and receive, like in frustration, for instance, whereby you are already paid money and the other party cannot perform because of unforeseen event. You can sue and claim that what you pay should be refunded to you, or you can also ask for restitution that should be taken back to the person you were before the contract entered into. If these cases whereby restitution is possible. So remoteness of damages, there are some rules of damages. One of them is that what led to the sequence that led to that breach must not be remote. And in fact, the common way, and of course, measurement of also has to do with whether it's quantifiable in monetary term or things like that. But then there's a case that you need to everybody must know this case, Harley and Bazender, 1854 case, Harley and Bazender. Please, so once you go online and like 1 minute, so once you go online and provide this case, read this case for us. And I'll give you that 1 minute. Somebody fastest finger. 1 minute. Harley and Bazender. Very interesting case when it comes to damages.
Good evening, sir.
Yes, yes.
So Hadley versus Baxendale is a landmark case in English contract law from 1854 that established the rule for determining consequential damages in the event of a breach of contract. The court ruled that a breaching party is liable for losses that were reasonably foreseeable at the time the contract was made, meaning damages must arise naturally from the breach or be within the contemplation of both parties when they entered into the contract. In this case, Hadley sued Baxendale for lost profits due to a delay in delivering a crankshaft needed for his mill. The court found that these profits were not foreseeable damages at the time of the contract. This case sets a foundational principle that continues to influence contract law today.
So, is there any person that can also have that can give us the facts, just the facts? This was someone that has a milling factory. Then, the shaft had issues, so he sent to an engineer to repair. This order happened there. Now, so because the repair was not done on time, so the owner of the factory now sued the engineer that look, because you delay in supplying me the shaft, I couldn't fix the factory, and so I lost profit. So the agreement was the contract was for supply of, for repair of the shaft, right? But it was delayed. And as a result of that, you say, oh, there's a breach of contract for delay. And because of that delay, you pay me for losses, for the profit that I would have made if you had returned that on time. So the question here was whether those period of delay, whether they can claim for loss of profit for those period of delay. So the court was asking those questions. If you read further in the case, now, did you inform this person that look, if you don't return this XYZ, that this will be the consequences? No. And they also have the chance. They also have the chances of mitigating the loss. That is, they'll have the chance of buying a new one entirely, or informing that person the need for all of those ones. So if you see that the court said, look, that loss of profit was not reasonably foreseeable in the delay that was meant to. So you see that even you look further, not as if the person was deliberate. It's a normal thing that look that sometimes it took an item for repair. You may think it's a small something, but when the engineer will start saying, it's not a small job or things like that. So what I'm saying here is that look, it must be, reasonably fairly, and must be linked, they must have a close remote, the damage must not be too remote, must not be too distant. What led to that claim must not be too distant. So like in the case of someone, because someone had delayed repairing the shaft, then you are not attributing that to loss of profit. That is too distant, it's too remote. And of course, as I said, I expect you to go and read those cases, and note that the aim of awarding damages is to compensate, not to punish, you know. And of course, loss of bargain is the yardstick for awarding it. So, because it is not meant to punish, where a party, where there's a breach of contract, then of course you are expected to take steps to mitigate the loss. It's a duty. So if, for instance, now there was delay, you know that you foreseen the delay, what do you do to mitigate the profit? You just fold your arms and thinking that you wait until if this person does supply you crankshaft, the shaft the next 3 months, You just claim the profit from that person. No, you would have made steps to mitigate. So the point here is that you must note as business people in the local, where there's a breach of contract, you that is a victim, you must make efforts to mitigate the losses that will occur from that breach of contract. You don't need to, so that the award of damages is not to punish the other party for breach of contract. No, basically compensate you for what you have lost. So you must take steps to mitigate, right? Maybe insurance cover, for instance. You have insurance over your house. The house has caught fire. You had opportunity of removing some items from your house, but you didn't remove any item. You have insurance cover for you, but you are still required to go with fire extinguisher. So that if they catch fire, you have to use your fire extinguisher to quench the light, even though you have a comprehensive cover over your car. So you must take steps. But if you don't take such steps, then of course the law will not help you, as the case may be. Yeah.
Excuse me, sir.
Yes, yes.
So can we say that such steps to be taken as regards preventing maybe in a case of this delay from happening, or just suing someone unnecessarily, could be stating clearly in the contract, say for example, stating the consequence that if this is not delivered within this time, it means that this is what is happening, or that I'm
Oh
going to lose
yes.
so amount of
Oh
money.
yes.
And so
That's
maybe if
one
the
way.
person is in the know and still breaches that, then the
Oh
person can be
yes.
sued. Okay.
Exactly. So you see that is not remote. You know the consequence of what you're going into. You see, not do it. So that will not be remote. So but even at that delay, so now that was not there, but they also not do anything. They had money to even buy new one. They didn't buy. If you read the case further, they didn't do anything. They didn't even contact the person. They're only waiting that look, once you delay, you will charge the profit, charge to pay the profit that would have gotten. Even at that, who even guaranteed that look, you would have gotten such profit in the first instance? Hey, so that just, you must take steps to mitigate, to reduce the loss. That's what they're saying. But those steps must be reasonable, not unreasonable steps. You can't, because your car is burning down, then you can jump into the fire. No, that would be unreasonable. Or the house is burning, you can't jump into the house because you want to reduce your item. That would be unreasonable. It must only be reasonable steps that you just take to mitigate. That what efforts do you make? So even though you have items in the shop, you have insurance cover them. Yes, you still put burglary. You know, you open your market, there's protest. Instead of locking the shop and leaving, you open the shop because you have insurance, contract of insurance. Can't work that way. You must take steps to mitigate the loss and all of those things. Just that it has to be reasonable. Um, Damages for non-pecuniary losses. There are also situations whereby the breach of contract will lead to injury to your feeling, mental distress, annoyance, loss of reputation, and all of those ones. Under the old law, mental distress, annoyance, all of those ones, because they are not monetary losses in the old laws. Under the old regime, the law was that they were not actionable for a breach as a basis of action under law of, under law of contracts. So it means that where there's breach of contract, for instance, we can't say, oh, you suffer mental distress, you are anger, they were injured to your vein, your heart beats, everything, your BP went up, all those ones you can't claim initially. You can't claim under the law of contracts. They come under the law of torts, like private law of. Now, but presently they exist under the modern law. A breach of contract, you can, if you have heart attack, you are admitted, you can claim for that as well. If that breach of contract also led to question about your reputation, you can also claim on that as well, even though there are no monetary losses or damages. Mental distress, injury to your feelings, and all of those ones, you can actually sue. If you can prove. Remember that one thing about it is that if you are late, you must prove. So if you say there's mental distress, you must prove that indeed you went through mental distress. You know, if there are an injury to your feelings or annoyance or loss of, you must prove that look, those are what they call non-pecuniary losses, non-monetary losses. So when there's a breach of contract, you can sue for monetary losses. You can also sue for non-monetary losses. You know, so these are just in summary, the remedies are available for a breach of contracts, and that also brings to an end our discussion on law of contracts. Yes, question. Do you have questions? Questions? Okay, so if you don't have
No,
questions,
sir. Not necessarily a question.
okay, go on.
Okay, sir. So I wanted to ask that. So someone can sue maybe the company for mental health. Say there is a mistake. Say someone in the workplace took something home, or someone else stole something from the workplace, and all fingers were pointing at a different person. And in the long run, it was discovered that the person that was being accused is innocent. It was a different person that took that. So the person can actually sue the company for defamation of character.
Of course, very well.
Right.
Very well.
Okay.
Very well. You can
Thank
sue.
you.
Very well, you can sue, yeah. Right, so as I said, that brings to an end our discussion on law of contracts. That's it.
Hello, sir. Sorry, this is Choma. I was going to ask if it's possible for us
It's not
to
into hiding.
get the
It's not
slides.
into hiding, Abby.
No, sir, not at all.
I'm hearing your voice today for the first time. I wasn't worried.
I've been with you, sir. Thank you so much for the class. It's been very insightful. But we wanted to know when we'll get the slides because we're yet to get it.
I will send them because we're using it for other lectures.
Yes. Okay.
By Friday would have gone through.
Been done with every other person. Okay, sir.
So we'll now share it to all the
Thank you so much.
except for those that are doing full time. Those ones I don't know why they are lagging behind. They're not at the same space with you guys. I don't know, but we'll just see what we can do.
Okay, sir.
I will run through for all the part time. That is for Wednesday, Thursday, and Friday, so that we can now release the guideline, the slide to all of you.
Okay, sir. Thank you so much.
You're welcome, Chioma. All right. Enjoy your evening.
Thank you, sir. Thank you so much for your
Thank you so much, sir.
Thank you, sir.
Thank you, sir.
You're welcome.